Thank you, Mr. Chairman, members of the committee. This legislation, if I recall it correctly, is my stab at trying to overturn what is known as Chevron deference, or formerly known as Chevron deference at the federal level. Chevron deference comes out of what was a now overturned Supreme Court precedent that requires that when the judiciary is weighing the legality of a regulation passed by, say, DEM, Department of Health, or something like that, that the deference goes to the department. So the department gets to say whether or not the regulation is actually in accordance with the law, as to a person trying to appeal saying this goes outside the scope of the law, i.e. the legislature did not delegate this power to the administrating authority or to the regulators, and so they can't actually pass this regulation. Right now, generally speaking, in Rhode Island courts, they give the deference to the administration, to the regulator, and this is on par with, if you're in a criminal case, the judge, if the defense attorney were to call an objection, the trial judge would look to the prosecutor and say, should I overturn the objection or do I uphold the objection? That's where you would be. Any decision the judge makes, it's on par, like if you're going to try to go back and forth. So what this does is it's a very long, lengthy piece of legislation, but what it does is it brings back the ability of someone challenging the legality of a regulation passed by one of our departments, again, specifically DEM, Department of Health, things like that, that they would be able to actually challenge the legality of the regulation. As of right now, the judge gives deference to the departments and almost always rules in their favor on situations like this. Couple of examples I can think of in the past, if you look at public water sources, okay, Department of Health passes a law that says what is a public water source? Well, we don't mandate, we don't dictate that in law. We've never dictated what a public water source is. So to give you an example, my police department is they have a well, and they are regulated no differently than the Harrisville Fire District in terms of, or I should say now the Clear River Utility District, in how they have to maintain that well, because they are a public water source no different than the public utility in the town. So you can see the mandate. I mean, I understand the need for health and safety and things like that, but is a police department's private well really on par with a municipal water system? And do they need to live up to the same mandates or regulations that go along with it? And this applies also to a lot of small restaurants. I have a restaurant in town that tried to reopen, but because the license had passed, they had once not been, because they were grandfathered, they had been grandfathered, so they did not, but they were not a public water source because they were grandfathered, but because their license lapsed, now all of a sudden they're a public water system, and they are regulated like that. And the owner of the restaurant has no real judicial recourse, because the judiciary always looks back and looks at the regulator, just like, again, if you're in a trial, if the trial judge looks to the opposing attorney and says, should I upheld this objection or should I not upheld this objection? And it's just weighted against the common person.